down in the German ports and how Jews have found their way into German ports. And I'd like to differentiate, if possible, between the first case and the second case. And the first case deals, as you mentioned, with the case of a woman whose husband has died and she cannot remarry unless because there are no children, she cannot remarry unless the brother-in-law releases her. That's, I understand, the case, right? Now, here it seems, as you described, Abraham is a rather wealthy Jew with connections to the royal court. And he's able to use his connections to move this case, or to, if you like, into a different jurisdiction. Now, I'm not sure that everyone will be able to do this in a case of marriage. And I don't know, but you'll have to correct me, but I'm not sure that the court would even be willing to get involved in a case of marriage. But if he could change the nature of what's at stake, the court may be willing to enter this. But this is not unique. As correct me if I'm wrong, but I think in Trieste we also have this. Something like that people are able to use their influence to move where cases are handled. But the second case, I think, it's a good example of Jews trying to go beyond their internal community to deal with this. Now, these people, as you mentioned, Khan is well known to us, and he occurs in the rabbinic court. He appears there in the rabbinic court of Frankfurt, as we know from other sources. And yes, he had a lot of debtors when he died. He died broke. So this is a case that we're familiar with, or if not specifically, but the people involved. So we're familiar with. But what's fascinating here is that they've brought the sources of Jewish law right into the German courts. And the German courts now have to deal with it. So the case, or at least the argument of the case, seems to be that Jews are taking their claims based on positions of Jewish law, and that's what you have before us here. We have here the text that comes from the Code of Jewish Law, Shulchan Aruch, the 16th century Code of Jewish Law. Interestingly enough, when the code is copied, it's copied without making any differentiation between the author, or one author, Joseph Caro, and the other, Moses Isserles. It's just straight run-on. Moreover, even the sources provided much later in the 17th century are copied simply as part of Shulchan Aruch. It's just a run-on without making any sort of differentiation between sources. But clearly, they've just turned to this code. And that's true of all the sources. Aulic was kind enough to send me the Hebrew that appears in this case. All the sources, the legal sources that are cited, are all from Shulchan Aruch. Now, but that's not the only source that they cite in this document. I don't know if you have here, but there's also from the Pinkas of Krakow, Pinkas of Frankfurt. Do you have that from there? If you can. They also use here, they copy material from the Pinkas of Frankfurt in Hebrew and bring that to the court. But all this is signed by two Jewish lawyers. Two Jewish lawyers sign off on all as being a correct and true copy, meaning that they've also become involved in this. Now, somebody has to do the translation, as you noted, as you mentioned. So that translation is, I assume, done by two Jews, or a Jew who translates it for them. Who does the translation? You don't know?
Yes,
no, but the date, that's 1627. Right, so that can't be, either the date has to be...
No, I mean the date is from the origin of the law book.
Yes.
And it was translated in the year 779.
Right.
But of a lawyer, of a Christian lawyer.
Does he do the translation, or does he sign off on the translation?
He said he has read the Hebrew original. He confirmed that it's word by word the same, and he translated it by himself.
He translates it by himself. So when we have the Hebrew, and I have to say, German was not clear enough for me. The Hebrew I can guess, I can speak letters, but I need clearer German to read. Is it a straight translation? No, it's supposed to be. That's what it's supposed to be. It's a translation. It's supposed to be a translation. Okay. So that, I think, is something quite, at least I have to say, I have never seen that before. I've never seen that Jewish codes are brought right into the German proceedings. And that, I think, is really quite astounding. And that questions the place of both Jewish autonomy, but also what is the place of Jewish law within, as you mentioned, Stefan, within the greater Holy Roman Empire? How are there are multiplicities here? Is Jewish law recognized? Apparently it is. Or at least these people have the right to make the claim. They haven't hired German lawyers to argue it based on German law, but rather their first attempt is to say that we're going to argue on the basis of Jewish law, and we want to know who's correct.
This is by virtue of a general privilege. And where does this derive from? A general privilege? Or like what Stefan said, once you already begin to recognize that there's Catholics and there's ecclesiastic law, and then it's sort of a derivative of this sort of toleration for multiplicity of ecclesiastic laws. So
that's, I think, one of the issues. If Stefan is correct, then we're talking about there's a toleration for other systems.
it's not because of the privilege.
No, it's not.
It's not the privilege. The privileges,
It's
the old
structure.
privileges which recognize Jewish courts don't play a role here.
I wouldn't put it this way, but say the Jus Commune simply was. I mean, we always look at one of the problems is a problem of perspective, that scholars interested in the Jus Commune were looking usually for what was common to all of Europe. So they were interested in the Jus Commune and Roman civil law being, at least in a subsidiary fashion, valid in France, the Netherlands, in Germany, and Italy. And so they were looking at canon law. Yeah? Also, the Protestant territories, canon law was still a different way, but nevertheless, it was also in a subsidiary fashion a valid general law. And so far, the focus of research on Jus Commune was on these commonalities. Yeah? And we were not that much looking into the particular laws. Yeah? And here, Jewish law, you could say, is just one of 100 different particular laws that were valid in the whole Roman Empire. Village laws, city laws, the tribal laws, the most important one, Saxonian law. I mean, half of Germany.
The Magdeburg sort of.
Yeah, Magdeburg, basically the whole eastern and northern part of Germany. There, Saxonian law was the most important regional law. Then you have Bavarian law, Hesse law, the law of Lübeck, yeah, and it appears that Jewish law was recognized as one of the particular laws. This is how it fitted into the system, you could say, but of course it raises additional questions. I mean, as I tried to point out, say, for the Imperial Aulic, for the judge at the Imperial Aulic Council, even Lübeck law was in a way accessible. Yeah, I mean, he might not have got a training in Lübeck law, but he could get on his own an idea of how Lübeck law differed from the regional law valid in Lower Austria also. Whereas obviously Jewish law posed additional questions. I mean, perhaps the closest analogy would be to look at what remained of Slavic laws. Yeah, in some parts of the Holy Roman Empire, you had Slavic communities, yeah, which also had their own legal customs. That would perhaps be the closest comparison. But still, Jewish law would raise additional questions. How we had to translate it. We had to figure out things work differently.
Also, what was the extent of acceptance of